I simply cannot overemphasize the importance of a properly drafted buy-sell agreement for our business owner clients. Many of our clients through their estate planning process will simply just focus on the succession of who inherits the assets upon their passing, and they will just simply assume that the business kind of goes along with it. But it's very important that a buy-sell, which used in its traditional format as an estate planning and succession tools, allows for the buyout at an agreed upon price of the deceased owner's portion for the benefit of their family. But not only does it accomplish that, but more importantly, strictly from a lifetime benefit, a buy-sell agreement can have what we call involuntary transfer provisions built into it. An involuntary transfer can happen in a couple of situations. One could be, of course, the claims of a creditor trying to take away a debtor's interest, or that not the creditor, but maybe the U.S. bankruptcy trustee in cases of the insolvency of one of our business owners. So that also can be a triggering event. So here we're using a buy-sell agreement not merely as an estate-driven tool or an involuntary transfer on death or incapacity, but here we're using it as an asset protection tool. So allowing for the non-debtor owners to be able to grab the interest, carry it over, and pay off the debtor spouse at a discounted rate. Why a discounted rate? Because now the non-debtor owners now run the risk of having to deal with potential litigation or collection actions by the debtor spouses. So we should have not the agreed upon value, not the appraised value, or a value that's discounted at, I don't know, say 50%. And when it is purchased, we can then have payout provisions that allow for a payout over, let's say, 10 or 15 years. So not only are the non-debtor owners able to acquire the interest before their part of their business becomes at risk by a creditor, but then we can create a payout schedule. It doesn't create an economic hardship on the business, and also, creates less of an incentive for a creditor to grab that, because not only are they not going to get the stock from a turnover order because of the buy-sell trigger, but what they won't even get the current value. They're going to get a discounted value paid out over time, which again seems like a less attractive asset to a creditor, which ultimately is one of the objectives of overall asset protection. If the asset is not attractive, they're not going to go after it, and as a result, that asset is quasi-safe. So this is one of the various tools that we use that integrate both estate planning as well as asset protection planning. So if you're a business owner and you have partners, you need to make sure that you have an effective buy-sell agreement as part of your overall your overall estate plan. So please reach out to me. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all of your tomorrows. Thank you for your attention. Bye-bye.